Good morning. Let's start with this. 3 police officers charged in connection with the killing of teenager Nathaniel Julies are appearing in court again this morning. The reason I insist on saying killing is that, of course, there's going to be a whole court process that will determine whether or not it was murder. The police officers are charged with that particular crime, and the charge is one of murder. Their formal bail bid is expected to continue. In fact, it's continuing as we speak. And let's take you live now to the Protea Magistrates Court in Soweto for those proceedings.
My colleague, because of having presented this issue, gave me an assignment and I went to read about the doctrine of common purpose. And I could understand why there was perhaps a confusion. Your Worship, it's a commentary on Snyman. It's a 4th edition. It's on page 265. It's under paragraph 1, 2, 3, under item number 11. It says common purpose and dolus in virtualis. Your Worship, I know this is it's an investigative and a criminal court, but because this aspect has been introduced, I need to counteract and expose the fallacy of the state reliance thereto. For X to have a common purpose with others to commit murder, it is not necessary that this intention to kill be present in the form of dolus directus. It is sufficient if this intention takes the form of dolus in virtualis. In other words, if he foresees the possibility that the acts of the participant with whom he associates himself with may result in wise death and reconcile himself with that possibility. Now, Your Worship, my learned colleague without facts introduced this subject. For this doctrine of common purpose to found any legal basis, they ought to have read out a statement that goes to the effect that we had planned that we will go to a scene and go perhaps and kill whomsoever that we find at the scene. We do not have that statement. As to where does he construct and conceive this doctrine of common purpose, you would not understand. And besides, there were 5 occupants in the car, excluding applicant number 3. My instructions were: accused number 1 was the driver, applicant number 1 was the driver, applicant number 2 a passenger in the front, and there was Stole, Hosi, and Fisach at the back. Now, these other 3 are not before you. We don't have a statement to say perhaps this one overheard these others that have been arrested to say that this one planned to go and kill whomsoever at the scene. I'm basically discounting the fact that they could have planned that we'll go to the scene and when we reach there we'll find an innocent disabled person and then we'll shoot at that person. Now, those things are not there. It's not there. Now, instead, the state is sensationalizing the case, emotionalizing the case, and not focusing on the strength of the state case. They must bring the case before you. It's not the responsibility of the court to descend from the chamber into the state docket, because otherwise that will amount to a bias against the accused person. So, Your Worship, the issue of common purpose is completely out, because let's look at it this way. Let's assume, hypothetically, that they acted on common purpose, which is far-fetched, which doesn't exist. So when does the common purpose end to exist? When does it cease? As soon as the victim is shotted. It's non-existent, Your Worship, with all due respect. Your Worship, I'll deliberately not comment on the statement of Ms. Harris. She's feeling pain. This case is emotional. All of us are affected emotionally, badly as a result of this case. The innocent life was lost unnecessarily. But where does the blame lie? Where does the blame lie, Your Worship? The blame lies in the dysfunctionality of the police services. Your Worship, I've explained to court that my client, since he joined the police, from the moment she took employment as a constable on the 12th of December to date, she has reported 4 different incidents of intimidation from the local drug lords in El Europa. There's not been a report back that came to her to say, this is how far we've investigated. This is how far we think you can assist us in terms of submit a statement here. There's none of that. Your Worship, as regards the requirements, because you see, I echo my colleague's statement to say that the court is a creature of statutes. Your Worship, the case can be said to be very strong. If you're not presented with incriminating evidence, there's nothing you can do. It's not your fault. To this end, Your Worship, I echo my colleague's statement that the provisions of Section 60 subsection 4A to E.
Before you go that far, yesterday when you read the affidavit,
Yes.
of applicant number 2 into the record, you mentioned this thing of drug laws. And I hear you still repeating it again today in your address. What is the relevance of these drug laws to the death of the deceased?
Your Worship, with your guidance, it may not be relevant. I thought, insofar as it's explained the dysfunctionality of the police service, the control, training and so forth, it could, if we had a proper functioning of the police services, the eventual unfortunate death of the deceased, this is my submission from the summation of what has been presented to me as an instruction, that had there been a proper professional service, police service, the way the incident happened could not have happened.
So is she saying management at the police station in El Dorado Park failed to pursue cases of the drug lords? That is why she shot this innocent young fellow.
That's not what she's saying. I'm saying,
Yeah.
there are 4 incidences thus far from the 12th of December to date about her being intimidated, arising out of a strict adherence to community policing and not wanting to take some bribes from the drug lords. In a way, you can take it further to say she's saying taking of bribes from the drug lords is very rampant at El Dorado Park. But I would recoil back. That is not, I do not want to take the issue as far. But for the record, nothing by the management was done insofar as to pursue that investigation, because had it been pursued, perhaps they could have come back in their management meeting and say, this is how we come up with an intervention. Your Worship, if I may proceed, I was still saying, I echo my colleagues' views immensely, that in respect of the provision of Section 64A, paragraph A to E, the likelihood of the applicant evading or absconding standing trial, it's non-existent. It's unlikely, it's unrealistic to mention that upon conviction, because the offense is grave, they are likely to get a lengthy sentence period in jail, and therefore will serve that as an inducement to run away from trial. It's not borne out by the facts. It's not borne out by the facts. Applicant is not a flight risk. she has cooperated thus far with the police. You see, the fact that the court may not have the full background information as to what exactly happened, it's on account of the state not wanting to open up its shoulders to court. Your Worship, we may want to discount it. I said to, and I'm saying this because if you were to stand up and want to introduce that kind of evidence, we'll object. Otherwise, this bail application preliminary inquiry will not end. I take instruction from client. Client tells me, look, I've cooperated with the police. This is what I've done. I've tried to tell them wholeheartedly, out of a guilty moral conscience that I feel, that my hand caused the death of the deceased. But objectively looking at that statement, applying the law, the state would not be able to run along with it until it proves an intentions against the accused person. So, the accused the applicant has proved that she's cooperated with the police. They drag her in collaboration with the police to go and make so-called a confession statement. But surprisingly, why is it not being brought before you? The applicant does not have previous conviction, he doesn't have pending cases or outstanding warrants we have mentioned all those. So, I wouldn't want to repeat there, Your Worship. We challenge the state, we say to the state, you do not have a basis for you to continue to ask the court to keep these people in jail. And besides, Your Worship, it is the purpose of arrest to secure the attendance of the accused in court. That is the purpose of the arrest. So, accused have been arrested. The court is determining whether they will be able to come to court. We are submitting that they will indeed come to court because there is nothing in law and in law that suggests that they will run away from standing this trial. Your Worship, the state also tries to drag the issue that there's a rioting at Eldorado Park community. Yes, of course, we know that has happened. And we know as we come to court, there are people placating outside. But, Your Worship, what does the law say? Let's put it differently, Your Worship. This is very serious. So, if we go along with the argument of the state, it means tomorrow if they come here and say, Magistrate Muhango must descend from the bench, that means he must descend and come down. So, it can't happen that way. It can't. We have got the law in the country. The court is guided by the law. You are a creator of statutes. You apply the law.
Is there anywhere where members of the community are dictating to the court not to grant bail?
I beg court?
I say, is there anywhere where community members are dictating to the court not to grant bail? Or is it not a factor which the court can take into account?
No, it's a factor which the court can take into account, but of course that has to be taken in cognizance of what the law says. Your Worship, I've been in this court for more than 15 years. We have had instances of the state versus Marohanye and the state versus Marohanye and others. This matter was before this court. We had people marching outside. The late, learned and brilliant presiding officer, Magistrate Orient. Notwithstanding what was happening outside, he did not allow himself to be influenced by that, but he applied the law. Your Worship, to a certain extent, we need to educate the community about the law. If we allow the law If we allow people not to observe the law, we will not have any rule of law in the country. And this institution is codified in the Constitution, it is enshrined, it is independent, it is fearless, it operates without fear or favor. There was also a complaint in Indonesia. I'm mentioning matters that were within the area of this court before Magistrate Fenter in Indonesia. There were matches there, but she applied the law and said, "This is what the law says. It is not for me to punish the accused by refusing them bail in anticipation of a custodial sentence. That would be a trial court to do." And I think this, as I mentioned, that reminds me of the state versus Achasen. I'm just going through my notes if I want to. The state versus Achasen, the 1991 volume 1, the South African law report. I think it is an appellant division. Yes, Judge Mahomet sitting, no, my correction, it's a Namibian decision in 1991 volume 1. Judge Mahomet remarked that an accused person cannot be held in custody solely in anticipation of a punishment unless the interests of justice are prejudiced. Now, I'm saying, objectively speaking, what interests of justice will be prejudiced when the accused come to court? I mean, when accused are admitted to bail, they will attend trial. The way this case is so clear is such that I'm trying to think which bail conditions can be imposed. Because the imposition of bail conditions is also not done for the sake of it. It has to address a particular legal issue. I'm saying what legal aspect if we were to request you to say no, impose bail conditions. If they will attack from, as my learned colleague says, if there will be people who will want to attack the family of the applicant number 2, those are the people that must be arrested. So that we reinforce the rigidity, the strength, and the supremacy of the rule of law in the country. Your Worship, I may also say that it's unfortunate. The NPA has constructed an extremely poor case, which case, as we go much deeper into it even borders one even to think that it is almost non-existent. Because who's going to testify in respect of so that they are able to prove the intentions of wanting to kill the deceased? There's no one. Just a minute, Worship. Your Worship, I was recording the proceedings and when I reached home, I replayed the recordings. When my learned friend, my colleague, was reading the affidavit, that is the statement that is an opposition statement that the accused should not be admitted to bail. In one trip he says, I submit that applicant formed part of a group of people acting with a common purpose. With a common purpose to wit crime prevention, and then developed and formed an intention commonly to go and commit murder. It's not borne out by the facts. And in law, Your Worship, there cannot be a common purpose that is constructed out of a lawful crime prevention. Because when they went out, they were lawfully booked out. Now, we are not explaining when did all of a sudden now that common purpose to go and do crime prevention now turns around to become an unlawful common purpose, which will then attribute and impute to any of the parties present into the commission of the offense. Now, Your Worship, we submit that the incidents happened at night. My client is not the one that booked out a firearm. Your Worship, I was even also trying to think, if she were to be convicted at worst or most, which element in the form of culpa is it? If we subdivide mens rea, will it be dolus, directus, or dorus in virtualis, or will it be negligence? Because dolus in virtualis and negligence, the difference, it's the distinct, it's a thin line. Now, it will be argued even during trial successful to say, could she have had a foreseeability that if she fired a rubber bullet, that will cause the death of the deceased? With what we have thus far, I'm confident if the state does not do much, the state may not be able to secure any conviction, notwithstanding all these admissions that have been made. So, the state case is weak, it's extremely weak, to a point of being construed as non-existent, and to that length, in the state versus Chabalala, the court decided that where the state case is weak, that is an exceptional factor. In fact, Your Worship, we need not prove numerous exceptional factors. One factor proven was decided in the avalanche of cases to be sufficient, so that the next leg should be, the next inquiry is whether the accused should be, whether it's in the interest of justice that they should be admitted to bail. And an inquiry is held with regard to the provision section 64A to E, insofar as to assessing the interest of justice. And I submit that none of that. My colleague goes to the extent of saying the accused's life is at risk. Worship, we submit with due respect that he's not being honest. Worship, unless if there is any other aspect that I did not address you on, that would be my submission.
Why did she shoot the deceased?
Your Worship, my instructions are that she shot to
Because you see, initially the impression I gathered is that probably there was a service delivery protest, or maybe there were people running around, or but from the facts presented by the state, it appears this young boy was alone next to this truck. And I'm at pains to understand why this young fellow was shot. See, I thought in your address you'll help me to understand and place factors why I should admit her to bail. But now I realized you're concentrating more on aspects which should be canvassed at the trial, other than factors which must be placed before me, why I should admit her to bail.
Yes, Your Worship, thank you. Your Worship, it is clear from the facts that are before court already, when she took out a fire and shot at the deceased, she meant to scare the deceased. She did not mean to kill him. Hence, in our affidavit, we say we do not have the requisite mens rea, that is a criminal intent to cause the death of the deceased. It was meant to scare her, and she labored under the impression that the same firearm was still loaded with pellets as had been previously safely used at El Dorado Park without any fatal incident. It was loaded with rubber bullets. That evidence is not being challenged. Unfortunately, at the scene, unbeknown to her, this firearm was now loaded with live rounds. And when she fired it, she caused the death of the deceased, unfortunately. Your Worship, based on these facts, and given these admissions, the state having been given an opportunity, it did not challenge that version. That version remains unchallenged as we stand before. So it is on that basis that we say the actus reus at the time should not be looked in isolation of what had happened at El Dorado Park and what she intended to do by firing this lethal shot at the deceased, which unfortunately caused the ultimate death.
You mentioned yesterday that applicant number 1 is threatening number 2 with death.
Yes.
Now, if she's out on bail, won't number 1 go and kill her, as you mentioned yesterday?
Your Worship, I will have to say it here, but I thought we would not disclose it because the court want to find out, and then I will have to address it. Your Worship, the applicant number 2 is currently being held at a secret venue because of acknowledgement on the part of the state that she has received death threats. But, Your Worship, to keep her in custody in lieu of the protection of her life, Your Worship, if the threat is so serious against her life, Your Worship, I guess we will get instructions to approach the police. But we don't have that instruction at the moment, and we do not think that was mentioned as part of trying to demonstrate that when the trial court will come and decide on a conduct, it will most obviously have also to consider how she reacted immediately after the incident.
In fact, if I were to sum up my question, is that don't you think that if she's kept in custody, it will be safe for her, other than to walk about in the street where she can be attacked and be killed by applicant number 1, as you mentioned yesterday?
No, Your Worship, we do not think so.
No, sir.
Incarceration on its own is a punishment, and it should have been punished for observing the law. That means our society will have now deviated from protecting people who are observing the law against those that are disrespecting the law.
No, I see.
There's a court process.
Thank you, sir.
first issue that I want to address before this court is the issue of the schedule, Your Worship.
The issue of
The schedule of offence in which the applicant number 3 is facing. Your Worship, the defence is of the view that accused number 3, the offence in which is facing, it has to be schedule number 1. And then I will read it on the CPA, Your Worship. Under schedule 1. Any offence except the offence of escaping or from lawful custody in circumstances other than the circumstances referred to immediate, under the punishment wherefore may be a period of imprisonment exceeding 6 months without the option of a fine. Your Worship, I don't think that the charges in which is facing, Your Worship, is it Schedule 6 offence, Your Worship. It's assessed after the facts, defeating the ends of justice and possession of unnecessary ammunition, Your Worship, life ammunition, Your Worship. Your Worship, but however, I will leave it to the court to make a ruling with regard to that aspect, Your Worship. I'm just addressing it, Your Worship. But however, it will be the court to decide, Your Worship, with the issue of the schedule, Your Worship. Your Worship, there is no concrete evidence, Your Worship, especially to the applicant number 3, which shows that indeed on the day in question, Your Worship, he did take part with the investigation at the scene of the crime, Your Worship. Your Worship, he was off duty on the day in question, applicant number 3, and then he was called by the applicant number 1, while applicant number 1 was in bar, Your Worship. So, good question to ask. What happened at the scene of crime while applicant number 1 was at home? Applicant number 3 was at home. What was happening at the scene of crime? No problem, let's go further. He decided to go to bar to meet his colleague. What was happening again at the scene of crime? After, Your Worship, you have the discussion with his friend, Your Worship. At a later stage, he went to the scene of crime, Your Worship. Your Worship, and on the day in question, there were Warrant Officer Neshikweta, he was on duty. There is no evidence from the state side stating that due to the accused applicant number 3, it was difficult for him to construct evidence at the scene of the crime. There is no such evidence, Your Worship.
Was he not off duty?
He was off duty, Your Worship.
Now, why did he want at the scene of crime?
Your Worship, Your Worship, what happened is that after this shooting happened, applicant number 1, he called him to come and assist him to report the matter to the police station, in which he did. He called his commander, Your Worship, on the day in question, telling them about what happened, about this matter, Your Worship.
My question is, in my understanding of your submissions, applicant number 3 was sick, he was off duty. But there are other officers present at the police station. Number 1 does not call the people who are on duty. He decides to call his friend who's off duty, who's sick. And here he comes, he runs to the scene. Why? Didn't he find it important that those who were on duty should be informed about what happened there, so that they can go and secure the scene, other than him who was sick?
Can I approach, Your Worship?
Yes.
Okay, Your Worship, I've taken the instruction, Your Worship. Your Worship, reason being that there were duty officers on the day in question. But after the incident, there was no person who was attending the scene of crime, Your Worship. Then, applicant number 1, when he called him, Your Worship, it was for the accused applicant number 3 to assist him, Your Worship, so that he can report the crime, Your Worship. He can inform the duty investigating officer also, Your Worship, about the incident, Your Worship. And then, Your Worship, he did visit the scene of the crime, Your Worship. And then in which, Your Worship, he got those 2 bullets from one of the community member was present there at the scene, Your Worship. But Your Worship, again, what did he do with those two bullets, Your Worship? He took them to the police station and they were booked. For him taking those 2 bullets to the police station, was he defeating the ends of justice, Your Worship? No. Your Worship, accused number 3, Your Worship, he doesn't have any reason, Your Worship, to benefit from the crime which happened on the day in question. And then, Your Worship, when this incident happened, Your Worship, it happened while he was off duty, but it emanated from the accused number 1 and number 2, who were on duty on the day in question. They drive along the Eldorado Park and then go to Freedom Park. And they came back, Your Worship, to the Eldorado Park where they were this track that we are talking about, Your Worship. And then, Your Worship, good question to before this court is that, Your Worship, they said that at first this child who was peeping along next to this trailer, they chased him with a siren. The child departed and come back at a later stage. It's when they okay, I will withdraw those as submission, Your Worship. But my submission is that at all material stage during the commission of the crime, it was not there, and it was not part and parcel of the commission of the crime. And then the issue of common for purpose, Your Worship, it can't gel, it can't fit for him, Your Worship, to stand, because, Your Worship, if it was planned, Your Worship, he was not there at work. And then during the end result of the commission of the crime, Your Worship, still he was not there. He just emerged after when he was helping by reporting the incident.
You see, unless if I don't understand these issues quite correctly, you see, I'm under the impression that if you are booked off sick, it means you can't go to work. You must be at your house. Now, he's booked off sick. He's phoned by applicant number 1. He leaves his bed and rushes to the scene. And here he appears before me charged with defeating the ends of justice. That's where I find it difficult for me to understand. Because in your submissions you're saying he did not commit any offense.
Yes, Your Worship. Your Worship, the facts that I want to lay before this court is that, Your Worship, I do agree that he was booked off sick. And then he was called by his co-accused, by applicant number 1, to come and help him, Your Worship. Okay, why he was called to help him? A good question to ask, Your Worship. And then the answer is, Your Worship, applicant number 1 he was shocked. And then he needed an assistant for this matter to be reported, Your Worship. And on the day in question, this might have been reported, yes. Applicant number 3 is the one who called the duty officer on the day in question, his commander, informing them about what transpired.
Now, if he's admitted to bail and is outside, what guarantee do I have that you won't go back to the scene there to go and tamper with it again, if he was able to do so when he was off sick?
Your Worship, at this stage, Your Worship, the scene of crime, I'm 100% sure that the investigation has been done, Your Worship. Then for him to go in there at the scene, Your Worship, I don't think that there is any part of form of evidence in which the state is still going to rely on, which is still there on the scene of crime at this stage, Your Worship. Because there were duty officers who were busy collecting the whole evidence on the day in question of what transpired on the day in question. Your Worship, if this applicant number 3 indeed he did tamper with the scene, Your Worship, there were duty officers on the day in question. And there's no evidence before this court that no, this duty officer went to the scene. This is the situation. This is he found that the scene of the crime has been tampered with applicant number 3. There's no evidence. There's no such evidence, Your Worship. Your Worship, let's go back to this ammunition, Your Worship. He has the choice to take this ammunition to throw them away. But Your Worship, he decided to take those ammunition to book them to police station. Your Worship, which means he was cooperating. Your Worship, with the investigation and the evidence at the scene of the crime, Your Worship. He had the choice to throw them away, but he opted to take them to police station. Why? Because his intention is not to hinder any form of evidence at the scene of the crime, Your Worship. Your Worship, I understand that the community of El Dorado Park, Your Worship, they are furious because of this offense, Your Worship. Your Worship, now the whole community of El Dorado Park, Your Worship, they are having a clear picture as to what happened on the day in question with regard to this offense.
Come again?
Okay, I'm saying that the whole community of El Dorado Park at this stage, Your Worship, they have clear picture as to what happened on the day in question with regard to this offense, Your Worship. So, the community of El Dorado Park, Your Worship, they want justice. Is that all they want, Your Worship? And the justice, Your Worship, is not to keep them, the applicant who are before this court in custody. Your Worship, justice, it might be.
Then proceed and give me reasons why I should not refuse to refuse in bail.
Your Worship,
give me the factors, reasons why I should admit him to bail.
Okay, Your Worship.
Yeah.
1, Your Worship, the applicant number 1, Your Worship, I was happy yesterday when I saw the mother of the deceased saying that she got closure as to what happened to the child, Your Worship. Which is clear that, Your Worship, now, it changes everything, Your Worship, because when she got clear picture as to what happened to the child, Your Worship, she knows the truth by this bail application. Then now, Your Worship, is this applicant number 2 danger? It can impose danger to the community? No. The answer is no. He's a police officer. He's a first offender. Your Worship, that's the first time when he transgressed with the law, Your Worship. And then another issue, Your Worship, is that accused number 3, if he may be granted bail, he will be able to attend the court, Your Worship. 100% he will attend the court, Your Worship. He's having a fixed property. He's having he's owning a car, Your Worship. And then he's having a children, Your Worship. He's having all attachment within the court, this court of jurisdiction, Your Worship. Let's come to the evidence, Your Worship. Is there the applicant number 3 is not familiar as to what is outstanding on the docket. So I don't see him interfering with any form of evidence because the docket is with iPad. They're the one who will be dealing with the investigation, Your Worship. Let's come to the witnesses, Your Worship. Same applies. The witnesses are known to him. Your Worship. And then the court can
say he does not know the witnesses. You say he's not aware of who the witnesses are.
Your Worship, it's not like, and I'm addressing the court that is not aware about what is outstanding with regard to witnesses in the docket. Because only iPad, they know which witness they have to approach, which witness they have to deal with, Your Worship. And in Your Worship, again, the condition, if the court is going to admit him on bail, Your Worship, the condition can be granted. Your Worship, which will prevent him to do whatever that can interfere or intimidate the witness. Failure in which, Your Worship, will have to suffer the consequences, Your Worship. Your Worship, I'll refer the court in the case of S versus Branco, Your Worship, where he stated that it will be injustice for all applicants to be refused bail without considering the issue of the bail condition. Your Worship, this is the applicant in which the court can admit them to the bail and grant bail condition. Your Worship, now let's address this issue. Now the mother of the deceased, the committee of the El Dorado Park, they know what they get closure as to what happened, Your Worship. Are they still going to oppose bail against this applicant, Your Worship? The answer is no. Because they are aware about what happened to their son.
It's the state which is opposing bail.
Correct, Your Worship.
It's not the mother.
It's the state which is opposing bail, but they did mention the issue of the community, Your Worship. Court indulgence, Your Worship. Your Worship, the state does not have a strong case against the accused number 3. Your Worship, hence I've addressed before this court that there is no evidence, strong evidence, which linking the accused to this offence, Your Worship. Besides the issue of him being at the scene of the crime and collecting these 2 bullets only, which were booked at the police station. There's no any other evidence besides that allegation, Your Worship. That's why the defense is in the opinion that there is an exceptional circumstance which exists that accused number 3, applicant number 3, may be granted bail, Your Worship. The court will agree with me that if there was any evidence, I will just repeat this one. If there was any evidence, or if there was any person who was misdirected by the applicant number 3, Your Worship, during the investigation on the day in question, the state will be eligible to do so and tell the court that applicant number 3, he misguided this investigating was on duty on the day in question. But there is no such. As a please the court, Your Worship. That's our address. Unless the court want to address me to some other aspect, Your Worship.
No, I thought you will address me why he went to the scene when he was sick. But I hear you not saying anything.
Okay.
But nevertheless, not. Oh, you want to?
Correct, Your Worship.
Yeah.
Your Worship, he was called to come to by the applicant number 1 to come and help him to report the case, in which he did. He reported the case, and then he asked the applicant number 1 what happened. The applicant number 1 told him the story, what happened, as to what happened on the day in question. So applicant number 1, Your Worship, he's an investigating officer also, Your Worship. And then he was helping. He went to the scene of crime with the intention of helping even the state, Your Worship, to assist with regard to the investigation at the scene of crime. Your Worship. And indeed he went at the scene of crime, but there is nothing in which we can say that he hindered with any form of evidence at the scene of crime.
Yeah, I see.
After he attended the scene of the crime, Your Worship.
No, thank you.
Thanks, Your Worship.
Yeah. Yes, was good.
As a court, this is. Worship, I've realized that each of my colleagues has taken 30 minutes. So it gives us 30, 30, 30, which is 1 hour. If perhaps the court can then give me that latitude to also use that 1.5 hour effectively. Your Worship, I will firstly start with the address by my learned friend for accused for applicant number 5.
If maybe just take a tea break until 12:15. Court challenge.
So those are live proceedings coming from the Protea Magistrates Court. It's the hearing of the bail application by the 3 police officers who are charged with murder after the killing of Nathaniel Julies in El Dorado Park, and they've been applying for bail there. You've been hearing from their lawyers making the case as to why they should be granted bail and why their granting of bail would be in the interests of justice and not interfere with the investigation by the police into that killing of Nathaniel Julies. It's been quite a revealing, I would say, hearing that we've had in the last while. About an hour or so since we started taking it live here on ENCA. They're taking a quick break, a quick tea adjournment, and we will continue to bring you coverage from the Protea Magistrates Court. Our Avuem dealer is there with other updates. As you see there, officials from the NPA also inside court there. I say it's been revealing partly because of what has come out from the case statements that each of these applicants has made in terms of being wanting to be granted bail, some of the statements that they have made in that process have been nothing short of extraordinary. I mean, earlier on we were listening to the lawyer for accused number 2, that is Jeff Makubela, who represents Kaylin Whiteboy. Kaylin Whiteboy being accused number 2, applicant number 2 in this particular bail application. She is the police officer who fired the shot, we are told, who fired the shot that killed Nathaniel Julies, and that is not disputed that she actually fired the shot. But her explanation is what I find extraordinary, in that she says at the point at which she fired that shot, actually she believed that she was firing a rubber bullet. And that she had used this particular firearm earlier on during a service delivery and had fired rubber bullets from it and had no idea that she was going to be firing live ammunition. We've heard allegations that she feels threatened by accused number 1, applicant number 1 in the bail application. That is the police officer who's well known in the area of El Dorado Park, who is known as Simon Scorpion Ndjalvane. Basically, the allegation as made out by Kaylin Whiteboy in her bail application is that she has received death threats from accused number 1, Scorpion Ndjalvane. And there the magistrate asking, well, if we release her on bail, how will we ensure that she is safe and is able to continue to attend the court hearing? It's been extraordinary. I mean, issues such as who booked out the firearm. Kaylin Whiteboy, who fired the shot, saying that she did not even book out the firearm on the day of that particular incident. But most extraordinary has been the testimony, the submissions by the attorney for Foster Nechiongolo, who is accused number 3, and that's the person we were listening to towards the end there, and basically talking about that there's nothing that shows that the accused number 3 will interfere with the ongoing investigation. So we'll continue to give you coverage from that hearing.